Hello everyone, and welcome to this video tutorial on how to apply the law on intention to create legal relations to a contract law scenario. In this tutorial, we're going to be looking at the cupcakes and Daljit mini scenario. We're going to quickly recap the law on ITCLR, and we're going to look at how you use that idea structure to get a really nice answer to the question. As always, let's start by looking at the scenario that we've been given. So the situation's this: Cupcakes, a bakery, ran a promotion in which they hid a winning ticket inside one of their cakes. The poster said that the customer who found the winning ticket would receive a year's worth of free cakes. Daljit, a customer, was delighted when he found the ticket in his cake, but when he went to claim his prize, the manager of Cupcakes refused to give him anything, saying the promotion was, quote, just a bit of fun. And you're being asked to advise Daljit as to whether there is intention to create legal relations. So this is quite a nice question because you're actually being told what area of contract law you should be applying to the scenario. I think it'd be useful at this point if we just did a quick recap on what the law on ITCLR is. ITCLR meaning intention to create legal relations. Please remember that I've done a separate video tutorial that goes through all of the law and all of the cases on ITCLR, so it might be a good idea for you to go away and watch that video again before you try and apply the law on intention to create legal relations. But we'll do a quick recap then. The requirement of intention to create legal relations in contract law, if you remember, is aimed at sifting out cases which are not really appropriate for court action. Not every agreement leads to a binding contract which can be enforced through the courts. A person might have an agreement to meet a friend at a pub, for instance, and they can have a moral duty to honour that agreement, but not a legal duty to do so. And that's because, in general, the parties to such agreements do not intend to be legally bound, and the law seeks to mirror the parties' wishes. So in order to determine which agreements are legally binding in contract law and which agreements have an intention to create legal relations, the law draws a distinction between these two types of agreement, between commercial agreements and between social and domestic agreements. And this is quite a nice area of law, quite a nice topic, I think, because it's quite straightforward. There's not a lot of cases to it. And I think it's also common sense that in general, there is a strong presumption that agreements made in a commercial setting are intended to be legally binding. And conversely, agreements made in a social and domestic agreement or domestic situation, there's generally a presumption against intention to create legal relations. And I think that's what the general public would expect. Just have a quick recap of commercial agreements then. The first two cases, Edwards and Esso, both show the general rule that there's a strong presumption in a commercial context that agreements are going to be legally binding. So in the case of Edwards and Skyways, the claimant was a pilot working for the defendant and he was going to be made redundant. And the defendant promised him an ex gratia payment. And then they withdrew this. And they tried to go back on their promise. But the court held that they couldn't go back on the promise. The agreement had been made in a business context, and that raised a strong presumption that the agreement is legally binding. Equally, in the case of Esso, recall this involved a promotion whereby Esso were offering any person who purchased 4 gallons of petrol a free coin from their World Cup coins collection. And it was held that there was an intention to create legal relations in offering these coins because they were being offered in a commercial context, which raised a presumption that they did intend to be bound. So both of those show in the general rule. The other two cases on this area on commercial agreements are Jones and Vernon Pools and Confetti Records. And these show the exception to the general rule. So you can get away, you can rebut this presumption in favour of being bound if you use clear wording that you do not wish to be bound in this particular commercial setting. In St Vernon Pools, if you remember, this was like a type of lottery, and on the back of the ticket it said, quote, binding in honour only. And that phrase, binding in honour only, which was placed on the ticket, rebutted the presumption in favour of being legally binding, showing that businesses can get away from this presumption in favour of intention to create legal relations if they use clear wording. In confetti records, the use of, quote, subject to contract on a fax in the course of negotiations prevented the agreement from constituting a contract because it rebutted the strong presumption in favour of being bound. Let's remind ourselves then of the situation with social and domestic agreements. So with social and domestic agreements, as you'd expect, there's a presumption against the intention to be bound. And if you remember in Jones and Padavatten, an agreement between a daughter and mother was unenforceable. There wasn't intention to create legal relations. And similarly, in Balfour and Balfour, there was no intention to create legal relations between a husband and wife. But do remember that Balfour was distinguished in the case of Merritt and Merritt, where there was a written agreement after the couple had already separated, which in that case showed that there was intention to be bound. Merritt and Merritt is showing that you can rebut the presumption against intention to create legal relations in social and domestic agreements, but Wilson and Burnett shows us that the words have got to be clear to that effect. In the case of Simpkins and Pays, it was held that if money exchanges hands in a social and domestic agreement, then that indicates that actually there is an intention to create legal relations. Okay, so that's a very quick recap then on the law on intention to create legal relations. Let's go back to Daljit's situation here and see what is relevant to his case. So we've got Cupcakes, a bakery. I'm going to highlight that straight away, as I would do in the exam. That's relevant because that's telling me we've got a business here, okay, which this is looking like a commercial context straight away. They've ran a promotion in which they hid a winning ticket. I'm going to highlight promotion as well because that puts me in mind of the case of Esso Petroleum. Hopefully that made you think of that case as well. So I'm thinking, okay, bit like Esso, they ran a promotion, that was still held to be binding. The poster said that they would receive a year's worth of free cakes. Daljit's delighted when he's found the ticket, but when he went to claim his prize, the manager of Cupcakes has refused, saying the promotion was just a bit of fun. Okay, so what we can see here is that this is a commercial context because we've got this business here. They're running a promotion a bit like Esso, and on the basis of that, we'd say there's a presumption to be bound. What Cupcakes the bakery are trying to do here is they're trying to rebut that presumption. They're trying to get rid of the general rule that it's a commercial context and say they should be bound. So they're trying to use wording, just a bit of fun, to say that there was no intention to create legal relations. So they're trying to make it like the case of Jones and Vernon Pools and also Confetti Records. But can you spot a difference between this and Jones and this and Confetti Records? Hopefully, you've realised that the manager of Cupcakes has said this verbally to him when he's come to claim his prize. Now that is very different to in Jones, where binding in honour only was printed on the actual ticket, and in Confetti Records it said subject to contract while the contract was still being negotiated. Although this Cupcakes company are trying to say that they're not going to be bound here, I think the answer is there's a presumption that they are going to be bound. It is going to be binding. If they just wanted it to be just a bit of fun, then they should have printed that phrase on the poster or on the ticket. But according to this, none of that has contained that information. His ticket doesn't mention that it's just for a bit of fun. So therefore, it is binding and they're going to have to honour it. So now that we've spotted what we think the issues are, let's look at how we would write out a nice answer using the idea structure. As always, we use idea, we identify, we define, we explain, and we apply. And this is quite a nice straightforward area of law to do. You're going to start off by identifying that the issue in the scenario is about intention to create legal relations, whether your claimant, and you would use their name, so in our case, whether Daljit has an enforceable contract with Cupcakes will depend on whether or not there is intention to create legal relations. Now, in your D for ITCLR, you just need to sort of explain or define, what ITCLR is. So I've just put, not every agreement leads to a binding contract, which can be enforced through the courts. In order to determine which agreements are legally binding and have intention to create legal relations, the law draws a distinction between social and commercial agreements. You would then E, explain all of the rules on commercial agreements with your cases, and then explain the rules on social agreements again with your cases. Now, there isn't a lot of law in this area compared to some other topics that we've studied, so it's really important that you explain the cases fully, explain the exceptions fully, talk about the phrases, for instance, that were being used in Jones and Vernon Pools, say it was binding in honour only, to show the examiner that you really know the law here. Application is quite straightforward, so you need to say whether your agreement is commercial or social and how you know this. So when we were looking at Daljit, I highlighted the first sentence, Cupcakes the bakery. So I'd say this is a commercial contract because Cupcakes is a business, so it's a commercial transaction. You can't just say it's social or it's commercial and not say how you know, because you could have just guessed that. You then need to apply the relevant cases to your scenario and conclude on whether there's intention to create legal relations. On this slide here, I've done a bullet point mark scheme for the Cupcakes scenario, so you may want to pause the video here so you can have a good read. So I've identified, defined and explained as I've just talked about. Obviously in your answer you're going to be writing in full sentences. Mine's just bullet points so I can fit it on the slide. But if we look at the application here, I've said Daljit wishes to enforce the promotion poster against Cupcakes. Cupcakes, the bakery, has run a promotion, therefore it's a commercial agreement. In commercial agreements, there's a strong presumption that they intend to be legally binding, and that goes in Daljit's favour. And I should really have put in brackets there Edwards and Esso. But words can rebut the presumption, like in Jones and Confetti Records. But here the manager states it's only a bit of fun afterwards. It's not a clause on the ticket, like it is in the case of Jones. It wasn't in the course of negotiations like it was in Confetti Records. Therefore, it's likely to be binding, as in the case of Edwards, as in the case of Esso. So I hope this tutorial's been helpful in helping you to see how to go about tackling an intention to create legal relations scenario. I do advise that you have a go doing some of the mini scenarios yourself using the idea structure that we've run through in this video.